Got it.
Thank
Okay, so it is 10:06. I think we will call this meeting to order. I want to thank everybody that's here in person or on video today. And then we'd like to thank everyone who's listening, YouTube channel, or listening to their devices. So I will turn it over to Anna and let her do the roll call.
Yes, ma'am. Thank you. Presiding Officer Amy Milstead,
Present.
Thomas Griffin,
Present.
Jimmy Zook, oh. Sir, your mic is muted. James Spears,
Present.
Tasha Mora,
Present.
Gary Hoffman,
Present.
Charles Rash,
Present.
and Ken Ulmer.
Present.
We have a quorum.
Thank you, Anna. At this moment, I'd like to, I know you guys already introduced yourself, Gary Hoffman, Charles Rash, and Ken Ulmer. If you gentlemen wanted to take a minute to introduce yourselves to everyone that's listening, we're glad you're here, and thank you for devoting some time to the advisory board.
Thank you I know most of you, but for those of you that don't know me, I'm Gary Hoffman, and I'm with Toe King in Waco. My family's owned the business, started it back in '92, so I've been around the industry for about 27, 28 years. And I'm a '98 graduate of Baylor with a business marketing degree, and happy to be here to help.
Thanks, Gary. Charles or Ken, either one of y'all?
Yeah, most of you guys know.
For anyone who, you want to go ahead, Charlie? Okay.
How about you, Ken?
I'll go. My name's Ken Ulmer, and I've been in the industry all my life. Ran the present company for about 31 years. I'm the chairman of the Texas Towing and Storage Association and the chairman of the City of Houston Automotive Board. So I'm very dedicated to the towing and storage industry, and very interested in making this the best industry that it can possibly be. Although I think it's a pretty good industry in Texas already. And I'm excited to be here. I'm excited to be a part of this and hopefully keep the industry headed down the path that I believe it is, and keep things in line and protect consumers and make our industry a better place. Thanks.
I'm Charles Rash. Most people call me Charlie. Obviously, I'm from Houston also. I've worked in the industry for more than 30 years. I currently run 2 BSO, 720 light duty trucks. And I'm also excited to be a part of the board, and I'm looking forward to being in person.
Thanks, guys. Thank everybody for introducing themselves. And we couldn't go with introducing the new members and not recognizing our past board members that rolled off. That would be Miss Joanne Messina and Jeanette Rash. They brought valuable input, and we appreciate the time that they devoted to the advisory board and everything we're working on. Okay, with that being said, I think we turn it over to Miss Mary Winston for our video conference training.
Thank you so much, Presiding Officer. I think we've all had training individually in a few sets because this is something that's relatively new. We have a little bit of practice now, so I think we're getting a little better. However, we also know that things do pop up because who really understands Wi-Fi? I don't, but we're trying our best. This meeting is being conducted by video conference, and the public is watching via live stream. Anyone who wants to sign up for public comment or who signed up had a chance to do so later. If you'll see at the bottom of your agenda, there were instructions to do so. The meeting is also being recorded and will be available on our YouTube channel for your viewing pleasure at a later date if you are watching from home and you missed something. Here are some tips to make sure we have a successful meeting. Keep your microphone muted until you'd like to speak. Please put all phones on silent and turn off other sources of noise in your workspace. Fidgeting around, let's try not to do it. I'm a hand talker, so I tend to do this, and so I try to kind of keep that below the level of the camera because it's distracting. So if you can't help it, like I can't help it, I'm doing it now, right? State your name before you begin speaking. Raise your hand if you'd like to speak. There is, of course, on this platform, a way for you to virtually raise your hand. However, as our chairwoman is leading the meeting and we're all looking at different things to make sure this goes smoothly, we may not be able to read that hand raise on the platform. So doing this, yes, like we're in kindergarten, lets us be seen and acknowledged, and then you can be called on. Make sure your hand is visible. The presiding officer will call on you. When we're in person, we take a vote, and it may be not a roll call vote. Because we are virtual, it will be roll call. Anna will handle that. Call your name, and for whatever we have to vote on, we'll get a yay or a nay. If you have any problems connecting during the meeting, try to let the presiding officer know. We have staff working in the office to assist your connectivity issues. Stay on camera during the meeting, even if you aren't speaking. And this is for our members, of course. We may have staff that bounce in and off, so to speak, on camera, but they aren't required to stay on. But because of the Public Meetings Act, we need to see you and we need to hear you when you're ready to speak. If you get inadvertently disconnected, please rejoin the meeting in the same link that you used to initially join the meeting. As I said before, we've done several of these, and using this medium, we know that we may have a few awkward moments, a few minor hiccups or blips. No worries. We'll deal with them in real time as they come about, and we'll take a recess if need be to handle any issues that may come up. It's anticipated and it's okay. We'll adjust and we'll go through every agenda item and take care of everything we need to act on. I want to thank everyone for participating today. And if you have any questions, just let us know and we'll handle them in real time. Thank you.
Thank you, Miss Mary. We appreciate that. All right, it looks like we'll turn it over to Elizabeth Salinas Stripmatter for training of the advisory board members.
Good morning, everyone. Thank you for joining us this morning for the advisory board meeting. My name is Elizabeth Salinas Strittmatter. I am the Assistant General Counsel who is assigned to this program, and I've been on the program for almost 4 years. So it's hard to believe, almost 4 years. And I am actually being joined. We are starting something a little bit new in the General Counsel Division, where on the bigger programs, we are bringing in co-general counsel. So my co-general counsel on this program will be Mark Gladney. Mark has been with the department for several years. He is the GC who is on the used auto parts recycling. So he has some crossover with the tow industry, but he is working with me to train on the statute and the rules, and he will be helping out in this program as well. So you will be seeing both of us when we resume in person. You will see both myself and Mark Gladney. So I would like to welcome Mark officially to the program. I know he is on this morning. So thank you, Mark, for your time as well. So I am handling this morning some training that we do for the advisory board. And this is the required training on our Open Meetings Act, our Administrative Procedures Act, and our Public Information Act. And Anna will be running the screen for me. So Anna, if you could, I don't know how to signal you when to click over, but if you'll just kind of click over and do your best to keep up with me on the slides, that'd be great. We will have a copy of this if you feel like you want a copy, board members, after this meeting is over. Anna has a copy and she can provide that to you. So let's start this morning by talking about the Open Meetings Act, and I will have time for questions at the end if you have any. So if you could hold those just so we can get through the presentation, that would be much appreciated. But if you absolutely need to ask a question, feel free to jump in, take it off mute and jump in. So let's start with our first statute that we need to be aware of, which is our Open Meetings Act. And the purpose of our Open Meetings Act is obviously to ensure an open and transparent government. And so this act requires that meetings of any governmental body, including TDLR, be open to the public, be preceded by public notice of the time, place, and subject matter of the meeting, which for us is the agenda that our staff puts together. And the provisions within the Open Meetings Act are mandatory, and they are to be construed liberally in favor of open government. So essentially, everything that we do is open to scrutiny by the public, and everything that we do, for the most part, with a few exceptions, everything that we do is they are capable of watching our meetings, seeing what we're talking about, and engaging, as you'll see in the public comment portion if we have any public comments today. So let's start with some key concepts to remember in our Open Meetings Act. And one of the most important, if not the most important concept to understand is your quorum. Your quorum is a majority of members of, in this case, an advisory board as fixed by rule or statute. So in order to have a meeting and take official action, you have to always have a quorum of our board. All right. Now, what does it mean to deliberate or to meet and take some kind of official action? Deliberation means a verbal or written exchange among a quorum of a governmental body or between a quorum and another person concerning an issue that's within the jurisdiction of the governmental body. That's a lot of words. That's a lot of legal words. So what does it mean? It means when you, the board, when a majority, when a quorum of the board is discussing business that is before it, that you are charged with in your official capacity with handling, okay? So anytime you're doing that amongst yourselves, anytime you're doing that with a member of the public or with another person or entity, that is going to be considered deliberation. A meeting occurs anytime there's a quorum, which we've just discussed, and you engage in deliberation regarding public business or public policy over which you have supervision or control, or any time that you take formal action. And again, that's a lot of words, but it basically means when you meet together in a properly noticed meeting and you are deliberating and we have a quorum and you're talking about issues that are under your supervision or control, or you're taking formal action, you are subject to the Open Meetings Act, which means it needs to be properly noticed. We need to have agenda, all those good things that we'll talk about here in a minute. Here is notice. Notice requires advance written notice of the date, time, place, and subject of every meeting that's held. We at TDLR provide that notice in the form of an agenda, and the notice must be filed with the Texas Secretary of State at least 7 days before the meeting, and it also needs to be posted online by TDLR and the Secretary of State. A board cannot engage in discussions about a subject which is not included on the agenda. So for me, on this particular point regarding notice, that is one of the most important things for us to remember as we move forward in our meetings, is if it is not on the agenda, then we cannot engage in a discussion about it. That does not mean we can't engage in a discussion ever. It just means it has to be put on an agenda and it has to be properly noticed. So a lot of people ask us, what about social functions? What about conventions? What about workshops? Places where the industry gathers annually? Because I know that in the tow world, you have these tow shows and various conferences that people get together. And so what if you are all happen to be, or a quorum of you happen to be at a social function, a convention, or a workshop? So as we talked about earlier, a meeting occurs whenever there's a quorum that engages in a discussion about an issue that you are in charge of. And the question arises, can members ever meet in an informal setting without violating an Open Meetings Act? Yes, you can. You can engage in conversation that is incidental to the event, but if your discussions are, if there's a quorum of members involved and you're engaging in a discussion or you're making a decision about board or committee business, or you're seeking to take formal action, you have to be under the Open Meetings Act. If you're just sort of talking about an issue that's an outlier and there's not really, there is not a quorum, and this is not something that's necessarily going to come before the board or that is under your jurisdiction and control, you're free to talk about those. But the important thing to remember is if it is board business, if it is something that the board has input in or that is before the board for a formal action, be careful and make sure that you are not engaging in discussions outside of an open meeting. So here are your key facts to remember. Just be aware of any situation occurring outside of a properly noticed meeting where there are a quorum of members present or a quorum of members engaged in a discussion. Don't engage in substantive conversations relating to board or committee business or policy when a quorum is involved and you are outside of an officially noticed and scheduled meeting. And always be aware of the walking quorum. What is a walking quorum? A walking quorum occurs when fewer than a quorum of members engage in discussion about official business and then communicate those discussions to other members. So say, for example, Ms. Milstead is having a conversation with a board member about official business. And then the board member to whom she's talking turns around and emails that communication to another board member. You need to be aware that you could possibly be engaging in a walking quorum. So while fewer than a quorum of members participated in initial communication, if there's subsequent communication with other members, that will result in a quorum discussing official business outside of a public meeting. So be aware of that walking quorum concept. Sometimes it trips people up, and so just always be aware. Ask yourself, if I were to forward this onto somebody else, onto another member of the board, possibly am I engaging in a walking quorum? So here is an example. On a 5-member advisory board, 2 members exchange phone calls and emails expressing thoughts on an upcoming rule change and exchange research that they have each individually performed regarding the issue. And then one of the board members subsequently forwards that exchange to another member. That is a walking quorum by engaging in a small group discussion outside of a properly noticed meeting. Walking quorums can occur pretty much anywhere, on conference calls, video conferences, in hallway discussions, in emails, in text messages, and other new technologies like Twitter, Facebook, and instant messaging. So again, be aware when you are talking with each other and you're relaying information, you could potentially be engaging in a walking quorum. All right, so what do we do? What do we do to avoid a walking quorum? Well, here are our tips to avoid a walking quorum. You should not meet in small groups, discuss board or committee business, and then communicate those discussions to other members. You should not send emails or text messages to a quorum of members regarding official business, even if each email is addressed and sent to each member individually. It doesn't matter whether those messages are forwarded in a group or whether they are forwarded individually. So be super mindful of that one. Do not create posts on social media about board business where likelihood exists that a quorum of members could participate in discussions. Or do not ask a quorum of members, even on an individual basis, for feedback on comments on board or committee business outside of a public meeting. This is called polling, which is essentially conducting an informal vote on an issue. All right, so what are our guidelines for open sessions? I touched on this a little bit earlier, and I want to get into it specifically now. A board or committee is limited to discussing the specific items that are on the agenda. But what about public comment? Sometimes we have public comments come in and they have nothing to do with any of the items that have been noticed on our agenda. And that's fine. The public is given an opportunity to speak, and the presiding officer is always within their discretion to set reasonable limits on the commenters on the amount of time that they can speak. A member of the public or a member of the board may raise a subject that is not included on the agenda, but discussion of the agenda is limited to a proposal to place the subject on the agenda for a future meeting. So if a member of the public comes in and raises an issue that you all would like to discuss at a later meeting, that's perfectly fine. At some point, suggest to the chair, or the chair will herself ask for an agenda item. We can put that item on the agenda and we can have a full and robust discussion after it's been properly noticed, and after the public is aware that we will engage in that full and robust discussion. Okay, so to avoid violating the act on the basis of insufficient notice, you as members should limit your discussions to specific agenda items contained in the posting file with the Secretary of State, which is the same posting that Anna and our staff send to you in advance of our meeting. Avoid allowing discussions regarding specific agenda items to wander off course into new issues that have not been noticed to the public. Sometimes during our discussions, it's natural to talk about a related issue, not in an open meeting context. In real life, that happens. In open meetings, we can't allow it to happen. So we have to stay on subject. And again, if a related issue is something that you would like to talk about at a later date, we could possibly put it on the agenda and it can be talked about in a properly noticed meeting. Do not respond to or discuss issues that are raised during public comment. And this one is really hard. And we understand that this one is hard. It's hard to sit there and just kind of take in the comments, even though you really want to respond back or engage in a discussion. But we can't if it's not on the agenda. And so what do? We specifically identify items for future agenda, and you communicate those to the TDLR staff, and we will see about getting them on an agenda for a future meeting. All right, so this is like the not so fun part that lawyers have to tell you guys. There are potential penalties associated with violating the Open Meetings Act, which is why this is such a serious thing and which is why we give you the periodic training. So for a civil remedy, any person, including the media, may petition the courts to stop actions taken in violation of the Open Meetings Act. So if, for example, a board at TDLR were to take an action that for whatever reason violated the Open Meetings Act, any person can then go and say, no, they cannot do this. It was outside of an open meeting, and they can ask a court for court order to stop it. It also states, the Open Meetings Act, that a state action that is taken in violation of the act is avoidable. So essentially means it has no authority, it has no power. And so there are criminal penalties. Members who knowingly participate in a walking quorum or who knowingly participate in a meeting that is closed to the public are subject to misdemeanor criminal penalties. And those include fines of $100 to $500, confinement in county jail from 1 to 6 months, or both a fine and jail time. So here are our top tips. This is a lot of information. So here are the top 2 tips that the General Counsel's Office wants you to take away from this portion of the training. Our best practices are to avoid communications that involve a quorum of the board about official business outside of a properly noticed public meeting. And during open meetings, confine your discussion to items specifically posted on the agenda. And because lawyers always like to cite to our sources and give as much information as anybody wants to take in, we have created these citations for you. If you would like, you can go in and do some research on open meetings. The Texas Attorney General's Office does an amazing open meetings handbook that is just gives so much information about open meetings and what you can and can't do. So if you're ever interested or have a question, you can click on that and it probably will help you. And the OAG also does open meetings training information and videos. And of course, if you just have a question about the Open Meetings Act and you'd just like for a quick answer, you can always feel free to call me or Mark. This is our General Counsel main line. They can put you towards us, or you can email us and we'll get back to you. Okay, so the Administrative Procedures Act, also known as the act that governs rulemaking. And this is probably the second most important act behind open meetings that you're going to deal with as board members. So the purpose of the APA is to establish minimum standards of uniform practice and procedure for state agency and to provide for public participation and transparency during the rulemaking process. Okay, so what is a rule? A rule is a statement of general applicability made by a state agency that implements, interprets, or prescribes law or policy, or describes the procedure or practice requirements of a state. But what does that mean? So you all are aware that we have statutes that govern both the TOW and the VSF program. Those statutes are enacted by the state legislature. And the state legislature in our both TDLR governing statutes, excuse me, and in our statutes relating to this particular program, the agency has been given rulemaking authority. And so the rulemaking are kind of the nuts and bolts of the statute. The rulemaking are what we consider to be the standards that the licensees have to comply with. And the rulemaking is a very important process that has very specific steps. So what isn't a rule? A rule excludes a statement regarding only the internal management or organization of a state agency. Most importantly, something that is not a rule does not affect private rights or procedures. Rules affect private rights or procedures. Okay, and a rule, when we talk about a rule, we can either be talking about a new rule, an amendment to an existing rule, or the removal of an existing rule. So the APA covers rulemaking from beginning to end, including repeals. Okay, so what are our sources for rulemaking? Well, as I mentioned earlier, the legislature, they can make legislative changes to our statutes. Advisory boards are sources of rulemaking. TDLR staff who deal frequently with the program and are hearing feedback from licensees may say, you know, we might want to consider a rule in X. The 4-year rule review, which our programs are required to undergo over 4 years, and I believe TOE VSF did their rule review. I might be mistaken, but I think it was within the last 2 years. We did our 4-year rule review where we just go through and look at all of the rules and through a rule petition. What is a rule petition? A rule petition is when any interested person, any person, a Texas resident, a business located in Texas, another government subdivision in Texas, or a public or private organization that is not a state agency but is located in Texas, says, you know what, I think we need to have a rule on X, Y, and Z. So they will make a rule petition for the agency to review. The rulemaking process is very long and it is very involved. So we've created a flow chart to kind of take us through that process from beginning to end. And as you'll see here, we go from a rule idea and drafting to internal review and analysis. And then we have to send our our proposed rule packet to the governor's office for review. And then we bring it to the advisory board and we have our first advisory board meeting. And we go through that rule pretty much word by word. We discuss what the rule means, the intent behind the rule. And that is when the board gets their first chance to say, okay, well, we might need to make some changes here. We might need to make some changes there. Let's talk about some proposed changes to what you're suggesting. Then we will take a vote and you all will decide whether you are ready to send the rule on to the Texas Register to be published and opened up for our 30-day public comment. The public will have 30 days to comment on any proposed rule language. Their comments will be submitted to us. We will compile them, we will review them, and then we will bring them back to you all for a second advisory board meeting where we will discuss the comments, and we will actually go comment by comment and discuss whether those comments are actually applicable to the proposed rule or not. And then you all will take under consideration any comments that are applicable and whether you want to make any changes to the rule language as written. If you do not want to make any changes to the rule language as it is written at that second advisory board meeting, then you will take a vote on whether to propose those rules for adoption at the commission meetings. Then we will do an adoption notice and we will take that rule packet to the commission, and the commission will decide whether to adopt it or not. And of course, we will have an effective date of the rules. So that in a nutshell is the rulemaking process, and it involves a lot of people and a lot of time, and there will be a lot of discussion. Whenever you see a rule packet come through your board, you will have a lot of time to discuss it and to vet it and to do all of those wonderful things that we do during the rulemaking process. So I talked a little bit about the 4-year rule review. This is what that process looks like. It's not as intense. And here is what it is. You're on a 4-year program schedule, notice of intent to review. The public has 30 days to comment on the rules. We will, in general counsel, review the comments and make any recommendations to the commission. The commission reviews the rules and filings and may re-adopt the rules. And then the advisory board will be presented any comments and may recommend any changes on the 4-year review. And again, here are your rulemaking resources, which also are wonderful, and they are supplied by the Secretary of State, our government code, our applicable provisions of the government code, and our Attorney General Administrative Law Handbook, which is also a good resource and amazing. The Public Information Act. So the Public Information Act is basically that act. It's called, also known as the Open Records Act, which is intended to allow access to information about the affairs of government and the official acts of public officials and employees. So everything that we do. The act makes all documents, records, and other information relating to official business open to the public, with some exceptions. Public information may include any electronic communication created, transmitted, received, or maintained on any device if it is connected with official business. Let me slow down. Let me say that again. On any device, if it is connected with official business, this includes your personal devices. So be very careful when you're talking about official business on your devices. And I believe you all probably have received training on that, so I'm not going to go too deep into that. But the thing to know is if we get an open records request, and if you have information on a personal device that is the subject of that information request, and it's connected with official business, our open records attorney may be coming to you and saying, we're going to need that information pulled off of your device. But we have a wonderful attorney named Mia Settle who handles all of our open records, and she will walk you through that process. And she is always open to answering any questions that you have, even outside of this training, about the Open Records Act. And the act, the courts have said it is going to be liberally construed in favor of granting requests for information. So there are exceptions. As I mentioned a couple of months ago, those exceptions are very narrow. So we should presume that all of our documents, records, and other information relating to official business are going to be open to the public unless we can argue an exception. But the best practice is to always assume everything you're doing is open to the public. All right, so what happens in an open records request? It has to be written. And so if you receive a written request for records or correspondence from another member of the industry who says, I want all of the TDLR records on X subject for the following dates. If you think that that is a written request, and forward it to us. Forward it to our open records team, Mia Settle, who is our attorney who handles that. And they will take a careful look and say, is this really an open records request? Is it not? If it is an open records request, they will handle it from there. So the important thing to remember is if somebody says to you, I'm going to need to see some records on X subject from this date to this date. Do you have anything? You as a board member should say, I think that's an open records request, and I'm going to have to defer that to the Office of the General Counsel Open Records team. Don't produce anything yourself. And what will happen is if the open records team gets that and says, yeah, you know what this is an open records request, they will start gathering all that information. We have people within the agency who are designated liaisons who will start looking for the information that is responsive to that open records request. If they think you might have any information, they will contact you, and please respond as soon as possible because they are under tremendous deadlines to respond. And in fact, they have to respond no later than 10 days after receiving the request. So super important that as soon as you get what you think is a written request for TDLR records, and if you think it looks like a public information request, immediately send it over to the General Counsel Open Records team. And then they will immediately start working so that they can respond no later than 10 business days after the after the request was received. Any delay in that can potentially be problematic. So the important thing to remember is once you get it, send it over. And an important thing to remember is we can't ask why someone wants records. Our General Counsel Open Records team can ask for clarifications, but those requests for clarifications need to come through the Open Records team. And we, as board members and as TDLR staff, cannot ask why they want that information. The presumption is they get that information unless an exemption applies. All right, so as I say, the general rule is presumption of openness. Now, I did say that there are some things that are not subject to open records, and there are some things that can be redacted from our open records outside of things that can be exempted. So whenever somebody requests open records from us, our open records team goes through page by page and literally line by line to look for information that needs to be redacted. And that examples of that information will be dates of birth, some email addresses, certain education documents, information that is protected by HIPAA, or information that is otherwise protected by the Texas Medical Records Privacy Act. So this is another reason why it's very important to just let our open records team handle any request for records, because not only are they looking for whether something is an actual open records request, they are looking line by line in any responsive documents to see whether exemptions apply or whether redactions are required. So that is a super short, compressed training on open records. And it's actually a more complicated area than that. But for purposes of what you all need to know, just remember, if you think it's an open records request, send it over, let our folks handle it. Don't try to produce anything on your own. And again, we have Public Information Act resources that are available, lots of guidance given by the OAG on this. And of course, our government code, Chapter 552 on public information is what spells out our Open Records Act. So that is all of the training that I have for you all today. I did say that I was going to open it up for any questions, if you have any questions on any of the 3 statutes that I've covered. So if you do have questions, feel free to raise your hand and take yourself off mute. I'll give you a couple seconds to do that. Okay, wonderful. Oh, I'm sorry, Mr. Ulmer, do you have a question?
Just a quick one. How would we know if you have an open records request that we may have some records of?
Very good question. So our open records team will contact you. If they think that for some reason a board member may have some responsive documents or responsive records, Mia Settle and or her staff will contact you directly and say, we have this open records request and we think you might have information. We're going to need you to look for the following things. And they will tell you very specifically what they need you to look for. And they will walk you through that process. And they will also walk you through what you do if you find any records that are responsive, how you send that to them, etc.
Great, thank you.
Does anyone have any other questions? Okay, so again, feel free to give me a call or feel free to email me if something comes up. If you want that presentation, Anna can send it to you. Send her an email and let her know. She will get it to you. And if you ever have any questions in the future about the applicability of any of these acts, please just let us know. That's why we're here. Okay, thank you.
Thank you, Elizabeth. We appreciate that. And I hope it was very informative for everyone. Okay, that makes us, next agenda item would be approval of minutes. I hope all you board members have had time to review the minutes from exactly 1 year ago, our last meeting. So if we don't have any questions, if no one has anything to ask questions or anything about, I will need a motion and a second to move forward on that.
I'll make a motion to accept those.
I'll second it.
Homer.
Okay, so we have a motion and we have a second. Anna, I believe this is where you now do a roll call.
Yes, ma'am. Can you tell me again who seconded the motion?
I have Ken Ulmer, who's, oh, second was Charlie Rash. I'm sorry.
Okay, thank you very much. Okay, Thomas Griffin,
Aye.
Jimmy Zoki,
Aye.
Kyle Jackson. Sir, you're muted. Say that again, please. James Spears,
Aye.
Tasha Mora,
Aye.
Gary Hoffman,
Aye.
Charles Rash,
Aye.
Ken Ulmer,
Aye.
and presiding officer Amy Milstead.
Aye.
Thank you. The motion passes.
Okay, the next item on our agenda is the public comment, and I believe everyone received the public comment that Anna sent out to us yesterday. To my knowledge, we don't have anyone present on this conference that will be speaking. Is that correct?
Yes, ma'am, that's correct.
Okay, so I hope everyone had time to read that, and we can put that on a possible agenda item for the next meeting, I believe is how that works. Okay, next on our agenda would be our staff reports. And first up is Field Inspections Division. I believe we have Ron Munoz that's going to talk to us about that.
Real quick, Amy, could I ask a question real quick before we move forward?
Absolutely.
That was one of the items that I had asked to be put on the agenda. Are we holding that for a future agenda item?
When I called in on that, because I thought I requested as well, and apparently it never made it to Anna's desk. And so apparently that's why it did not get on this agenda. So
Okay.
it will be on the next meeting, but I don't think we're going to wait a year to have our next meeting. That's the good news. So hopefully it'll be pretty quick and we will get that addressed.
Great, thank you.
Okay, Juan, I believe you're up.
Good morning, board members, TDLR staff, and our public viewers out there. My name is Juan Munoz. I am a manager with field inspections for our central region. That's part of our personal updates. I was promoted to that position last August. We had several other promotions in our division. Angela Sanders was promoted to one of our South region liaisons, and we had several, as you can see on the list, we had several individuals promoted to field inspector fives as well. We had James Turner, also one of our other new liaisons, was promoted for our North region back in November of last year. And then Colleen took her position, and she started the new lead facilitator position back in February of this year. So we want to welcome both of them, or welcome Colleen, and obviously thank Julianne for all her hard work. We appreciate that. So our statistics compared to this year to last year, obviously what we'll be looking at. We did suspend TDLR inspections March 17th of this year. So they're going to be some numbers are going to be a little bit off as from between like March and about July or so. But we are currently we're almost on track getting back into our on-site inspections, getting back onto the field. We are in the process of trying to work a virtual inspection for vehicle storage facilities. So that is in the works, and that's being worked on as we speak. Next, we have our top 10 violations. I'll just let you know that usually these are usually our top two storage lot signs, and most of the time it's just the signs are either outdated or they're not posted in the right locations, those kind of things, or don't have, in this case, the affidavit where people can actually see that sign, the instruments of release. And then the notice of complaint procedure, we always make sure that that's out there. And of course, we have the other 8 or so top violations for our VSF program. If you don't have any questions, I'll just move on to a quick update on some current projects. I did mention, that we did suspend our TDLR inspections this past March 17th in response to the COVID pandemic. After distributing personal protective equipment and providing safety training to field staff, inspectors began to perform limited on-site inspections in June 2020. Not only were we opening under restricted to health and safety concerns, but we also had a limited travel budget. In response to these concerns, we have successfully implemented a virtual inspection process for some barber and cosmetology inspections, and are drafting procedures to perform virtual inspections for storage facilities for some facilities. Y'all have any questions for me?
If I can unmute here. Okay, so there's not been any virtual inspections for the storage industry yet?
We've tested a few. Again, we're trying to establish what a good process looks like. So we're being very deliberate of how we're proceeding with that process. So we're just doing a lot of work groups, a little brainstorming, and how that's going to look, and how we can benefit both the TDLR and the licensees as well.
Okay, so it's a little early to tell how they're going. It's still premature.
Yes, ma'am. Yes, we are very, very early in the process right now.
Perfect. Juan, forgive me for not congratulating you. We're excited to have you as the manager of our field inspections division. So sorry about that. I did forget that piece. My other question was, do we have an idea of when things are going to get back to normal? I know that the state or the U.S. is still in just a turmoil with the COVID. Any ideas of the future when things are going to get back to normal?
Well, I'm probably not the right person to be able to answer that question. I mean, we take guidance obviously from our directors and from our executive, but we're trying to get back to normal as best as we can. We do analyze and take data in to see what areas we can actually go out to. So we do take a little bit of time to do that. Right now it's we had some counties that we just were not able to inspect, so it wasn't even so much that we couldn't get to them. It's just that the counties were kind of restricted for us. So that's opening up as we speak. So yeah, I hope for the next couple of months we'll be able to get back to that point.
Mary Winston, TDLR, Chairwoman, thank you for that question. And I wanted to kind of jump in right here and just say that we are moving very cautiously. So all of the research that Juan is talking about, thank you so much. And yes, congratulations to Juan. He's always done an outstanding job and it's so well deserved. And the different things that we're doing, and I'm going to touch on that a little bit in the executive report, but I want to make sure we move smartly. I'm today sitting in my office alone with everything as close to me as I can touch because when I leave the office, I do put on my mask, right? And some of the staff are separated. So as we move forward on testing how to virtually do these um, inspections and on where we can go out to, because even if our people are clear, certain counties aren't clear. And we are definitely following directives as they come to us, but we're not sitting on our hands. We are trying to figure out the best way for us to do it. So that is an executive question, and there's a team, and that team works with other state agencies, and we operate under guidance from the governor. And so there are all these different levels that we are trying to adhere to. So slowly and surely. I told one of my kids this morning because he does not talk as fast as his sister or move as fast as his sister because she wakes up talking. It's fascinating and off-putting, but I love them both dearly. That I reminded him that the tortoise won the race. So we want to win the race. We don't want to get out ahead of anything. We want to win the race. So sorry for interrupting, but I want you to know we're doing everything possible.
Thank you, Mary. We appreciate that update, and that puts a lot of minds, at ease where we are and where we're going. Board members, do you have any other questions for Mr. Munoz? Okay. I just, again, want to touch on congratulations to you, Juan, and then all the other changes that happened in your department. It looks like there was lots of promotions, lots of additions. So welcome to everyone in that division, and we're glad to have you, and thank you for what you're doing for our industry. Okay, that takes us to Regulatory Program Management Division. This would be Todd Forrester. Is he with us?
I am.
Hey. Hi,
Good
Todd.
morning. I'm Todd Forrester with the Regulatory Program Management Division. And we have had some personnel changes too. Recently, we have acquired Stuart Stranad. He comes to us after many years with the Texas Department of Agriculture, 22 years with the Field Operations Division, and 22 years of regulatory experience. Stuart has been great so far. He provides the support we need. He's a quick study on the law and rules. I believe a lot of that is because of his past experience. Very sharp guy who is beginning to understand the industry a little better. I look forward to us being able to go out and conduct trainings again and go to the tow show again, so the industry can meet Stuart. He's been a great addition so far, and we're glad to have him. If you ever get a contact from Stuart, say hi, or if you ever see him, say hi. So we have our statistics below, and that's pretty self-explanatory. We're keeping track of all the contacts still, all the reasons they're contacting us. We also have an industry compliance section on our website. That section has grown from around 1% of the web traffic on the towing and VSF pages to 4%, which is a pretty good growth for a section dedicated solely to the industry and helping the industry. Along those same lines, what that is essentially a broken out version of the compliance manual. And so whenever this pandemic happened, and this is speaking of current projects, we actually, with RPM for towing and VSF, we stepped up trainings. We've been doing many trainings on Zoom. Usually we have a big one once a month, usually around 20, 25 people. What that does and how it's been helpful is it allows us to do the trainings at no cost to TDLR. I don't have to go anywhere. Members of the industry don't have to go anywhere. We're able to incorporate people in big cities and in rural areas who may not have been able to take the time off to go to a training before. This format has really been good. It's helped, I think, a lot to get the word out for the law and rules. We also have provided for smaller areas. If there's a company in a rural area that needs some help, all they have to do is ask. We can get on Zoom, help them with whatever they need. We've really tried to use this pandemic to kind of shift to that model, and so far it's been pretty successful. And I've had fun doing it. It's been interesting to see the interaction with people on Zoom, to try to get people to interact on Zoom. But overall, I think it's been helpful. Are there any questions? No?
I guess not. That is great news. Everything that's changing in the web development that's going on, it's forcing everyone to do business in a new way, and I think it's going to be some good changes coming forward after all this. Congratulations to Stuart. Welcome aboard, and we're glad to have you. And Todd, thank you very much for your report. We've missed
Thank you.
Okay, that takes us to the Enforcement Division. Mr. Michael Shirk.
Hello there, members of the board. Can you hear me?
Yes, sir, we can hear you.
Okay, hopefully you'll see me. There, you can see me now. Good morning. This is probably one of the very first meetings I've been in this video context. So I brought in a table lamp just so I wasn't just silhouetted. We have been, as you can see from the personnel updates, seeing a lot of changes in the Enforcement Division. And what's really great is all these people have come up through the ranks and they really know the materials. And it's really, we've gotten a very tight, and in terms of institutional history, strong group of people now in the Enforcement Division. The first person you see is John Medlock, who's now our chief prosecutor. John is over the supervising attorneys, and then of course over the prosecutors such as myself. He'd been with TDLR for 7 years as a prosecutor and then a senior prosecutor. Another one of the prosecutors that moved up into John's old position, senior prosecutor position, is Trevor Thielen, and he'd been with us for 9 years before moving up into a senior prosecutor position. A lot of you probably know Jackie Revia. She was promoted to a legal assistant supervisor. She's been with us for 18 years. I think the department is a great place to work, and so people get some good tenure here. I noticed on this report that Denise White, who has been my legal assistant for the 5 years I've been here, wasn't mentioned, but I just want to give out a shout out to her because she's really paid some dues and did some great work. And on April 1st, she was promoted to senior legal assistant. And so she's given me more work than I've had in the past now that she's got some rank over me. Dave Hawkins was promoted to legal assistant supervisor. She's been with TDLR for 8 years. And then we had a couple of people who, after many, many years, decided to retire. One was Greg Dodson, who was the investigations manager. He's been with us for 22 years. And Daryl Kuntz, who was the prosecution legal assistant manager, had been with us for 18 years. He oversaw the legal assistant section, all the legal assistants and paralegals. They are leaving gaping holes. We do have the positions posted, and we hope to start interviews pretty soon. And then finally, on August 31st, senior investigator Esmer Arguillo retired after 21 years of service. And I didn't do any work in the building and mechanical water well and property tax programs, sticking pretty much just to tow VSF. But you know that after 21 years, there goes somebody with a lot of knowledge in building mechanical water well programs. So we've had a lot of movement, but it's been really good movement. People who have learned from the ground floor up are now moving up further. And that's the great thing about this agency is skill is truly recognized. I'm going to move over to the statistics right now. And it says through July fiscal year 2020. So for those of you like me who that's kind of cryptic, what this means, this data captures information accumulated from September the 1st, 2019 until July 31st of this year, 2020. The numbers are pretty self-explanatory. You can see in the cases opened and cases closed that we're just lagging a little bit between closing the same number of cases that come in, but that is understandable because cases keep coming in and they take work to close them or prosecute them effectively. We're still at about 197 days for closing cases. We're trying to get those numbers harmonized, but we feel that that's a good that shows a good steady work process where nothing gets too stale. Interestingly enough, I think the fact that only 6% of our cases for tow and 7.36 result in disciplinary action, and I'll touch on those numbers again, speaks a lot about the philosophy of the Enforcement Division, that we get, as you can see, hundreds of complaints every year. And it is the philosophy of the Enforcement Division that we would so much rather work with companies to assist in gaining compliance in open cases and prosecute or go after them for non-compliance. It makes for a healthier industry, and it also, I think, shows that TDLR is a resource to the industry and not an adversary. I think for too long, tow truck companies, BSFs, and other at least programs in my area, which is the transportation team, haven't really reached out to me as a prosecutor as much as a resource. And I'm glad that we're able to work these cases as helping companies rather than merely prosecuting them. The commission orders down on the lower half of that page, or the lower third of that page. Commission orders are typically orders that come in once an administrative law judge has heard a case at the State Office for Administrative Hearings. We present cases much like a civil case where we have the burden of proof. Evidence is put on. The other side, with or without their attorneys, generally they do have attorneys when these cases go to SOA, present their cases. We're bound by the rules of evidence, the rules of civil procedure, all those things. Once the cases are presented, the administrative law judge then makes a recommendation to the commission. Administrative law judges don't have the authority in the context in which we practice to make rulings. They make recommendations. Those recommendations take the form of a proposal for decision, and then those proposals for decisions are forwarded to the commission, and the commission can either accept, reject, or modify the proposal for decision. So when we see commission orders, generally those are orders resulting from a recommendation received out of the State Office for Administrative Hearings on cases that we've taken to prosecution because we couldn't resolve them any other way. The default orders are result from when we begin a prosecution, when we have sufficient basis to believe that a violation of law can be proven, we issue a notice of alleged violation. The notice of alleged violation is very careful to specifically identify the infraction that we believe has happened, talk about the law that had been breached, and then offer a settlement in terms of either administrative penalty or sanction. You know, we can go from administrative penalty under our penalty matrix of up to $5,000, or we can seek sanctions, which might be the suspension of a license or the probated suspension of a license, even the revocation of a license. And so the default orders, after we send out the notice of alleged violation, if people do not respond in the time that the notice of alleged violation instructs them to respond within, we will always make diligent efforts to make sure they're aware that they're about to be defaulted. In fact, we even send them letters and say, you've not responded to your notice of alleged violation. This matter will proceed to default, and the penalty or sanction will be issued without an opportunity for you to say anything. We also make one last phone call to make sure that this just doesn't happen to somebody without fair and adequate notice. So that's what default orders are, is when the notice of alleged violation is not responded to, and the executive director will issue an order implementing the penalty and sanctions sought in the notice of alleged violation. By far, the agreed orders. The agreed orders are simply situations where a respondent, which in this instance would be a tow company or a BSF, and the prosecutor agree on a settlement. And they put together a settlement agreement. The tow company or BSF will sign off on that, and it would agree to some sort of monetary penalty, maybe some probationary terms, such as requiring that drivers obtain more continuing education in the laws and rules governing towing operations. They might require that they submit so many tow tickets to us every 6 months so we can evaluate if the tow tickets are now in compliance. But the agreed orders are basically when we reconcile with the tow or VSF, and then it has the weight of an order, but it's an agreed order. As you can see, we've been assessing a lot of penalties. The collection has been troublesome. I think that has to do a lot with the economic times right now. Oftentimes, when we are not able to collect penalties, we do refer the cases over to the Office of the Attorney General for collection activity. I think the strongest tool that we have to seek collection of the penalties is the refusal to renew people's licenses if they're in default in the penalty payment that's been assessed against them or that they've agreed to in an agreed order. The harshest penalty that we can give somebody is the revocation of a license. We've revoked only 10 licenses. Given the number of tow and VSFs, that's a small portion. It's smaller than what we see in TDLR in general. The criminal history denial or revocation is based on the criminal history guidelines that we use. There are certain criminal offenses which are so intricately connected to the safety of the citizenry that if a person with that kind of criminal history seeks to go into the tow or VSF field, we would seek to deny them a license because of that criminal history. Interestingly, and unfortunately, a lot of these denials and revocations are because people lie when they put in their application for a tow or VSF license or renewal. They tell us that they don't have a criminal history, and we find that they do, and that's misrepresentation on their application for a license, and that could be grounds as well for the denial or revocation of a license. Cease and desist orders, we don't get them very often. Typically, the executive director issues them when we know that there's unlicensed activity going on. However, I was able to get a cease and desist order against a company out in Houston. They were engaged in a course of conduct, and even after I had received a proposal for decision from the administrative law judge sanctioning them for that behavior, they continued to do that behavior. And so we requested, and the executive director issued a cease and desist order prohibiting that company from continuing that course of conduct. The strength of the cease and desist order is that it's the first step towards getting the Attorney General's office to issue an injunction and possibly hold the company in contempt if the conduct is continued. And informally resolved, I like those big numbers that we have, because once again, what it shows is we really work with the industry to assist in gaining compliance and coming to understand what are really a very complex set of regulations and statutes. And so informally resolved means there was a complaint. We believe that the complaint articulated sufficient facts that a violation of the law could be proven, but either there was low consumer harm, or there wasn't mendacity, there wasn't an intention to harm, or we felt like this was an isolated incident. We informally resolved by seeking refunds, among other things, or changes in business practices, and we simply closed the case without any disciplinary history. And you can tell by those large numbers that, again, that really is the philosophy of the Enforcement Division, to strenuously protect citizens and consumers while at the same time serving as a resource and an ally for the industry. I'm going to move on now to our top violations. The, not surprisingly, largest one is tow without authority. This is a huge net. This could be maybe a tow occurred because there was no standing written agreement, or maybe the tow occurred when the car was not parked illegally. One of the cases I'll present to you is an instance where a car was double parked. That is to say, it parked across the white line separating one parking space from another. It was towed. That would fall within this basket of illegal tow. Basically, the law gives very finite reasons why a car can be towed. If the car is towed without that legal authority, then we chalk it up under illegal tow without authority. That is to say, the car was towed without legal authorization. Criminal activity, that's our criminal history work with the check of the criminal history background as well as revocations of suspension because of either having criminal conviction, being on deferred adjudication, or having misrepresented the status of a person's criminal history in making an application. We're still getting instances where people are charging more than allowed for tow, and we really see those are serious cases because so many jurisdictions, Harris County for sure, have got limits on what can be charged for incident management tows. Many municipalities have caps on fees, and too many towing companies are ignoring those caps. And we do, as a state agency, have authority to penalize and go after tow companies that charge more than is permitted by local ordinance. The lacks honesty, trustworthiness, and integrity. That number keeps climbing higher and higher and higher because of, unfortunately, the rampant flipping that's going on in Harris and Montgomery County, where a very small number of unscrupulous tow drivers are fraudulently inducing vehicle owners to sign documents which purportedly allow the car to be taken to an unregulated body shop rather than to a licensed vehicle storage facility. The second that car arrives at the unregulated body shop, somewhere in the area of $3,000 to $4,000 of bogus fees are tacked on automatically. Administration fee, transfer fee, safekeeping fee. These are usually cars that are total losses, and there's no reason for them to go to a body shop to begin with. But the forms that are fraudulently induced and obtained from the vehicle owners at the accident scene allow these charges to be tacked on, and it's one of the biggest issues we're confronting now in Harris County and Montgomery County is the flipping problem, and that's where the lacks honesty, trustworthiness, and integrity violations most often arise. We're still seeing towing without proper signage. I think the position here, we're pretty loose in enforcing this. Our standard is not to be nitpicky. If it's 60 inches off the ground, is the lettering correct coloring? Are the hours and dates make sense? I think we apply a very lenient standard, which is would a person of reasonable intelligence understand they could or could not park where they're parked. We're not busting heads because the signs are not at right angles or because maybe the colors are a little reversed. But it is important that people be given fair notice of who and when and where they're allowed to park before their most important asset is towed away. Safe and competent manner, we're still getting too many of these where cars are falling off the back of trucks. I know Prosecutor Reed had just recently prosecuted 2 cases where the tow truck driver picked up a car with people in it. The tow truck driver just did not make a reasonable inquiry, look around the car to see if there were people in the car, and there were. And we believe that the tow truck driver should have looked at the car before he just hooked it up and started towing it. The safe and competent manner, again, is not a judgment call. We don't have jurisdiction over damages to vehicles that are towed improperly. So if a car gets hurt during a tow, that's a matter for the vehicle owner to take up with the tow company's insurance company. But where the damage to the car is caused by such neglect and such lack of skill and carelessness that it shows that there's an incompetent tow performed, we will prosecute those because it's bottom line public safety. Towing is an ultra hazardous activity already. As you all know, the slow down or pull over rule applies to towing, and we expect tow operators also to act safely and know what they're doing with that kind of heavy equipment. failure to take to a licensed VSF, that's sort of the flip side of the flipping cases where the vehicle owner has been tricked into signing authorization, and because the authorization was a result of fraudulent inducement, that's not effective, and so we will charge those as failure to take to a licensed VSF. Unlicensed activity, that stays pretty consistent. A lot of that is people continuing to do tow operations with an expired license. We have a much lower penalty if the person continues to tow with an expired license within that 6-month window, because life gets complex. Obviously, how to perform tows, but when that 6 months has expired and they're performing tows, we will go after them, and oftentimes we have to get cease and desist orders for no company license, and it's it's a shame that there's pirates out there that are performing towing operations without a license, and we believe that having a license protects the public and it ensures accountability. So we will always prosecute cases where tow companies are operating without a license. Charges not related to tow. This has been an interesting one, trying to figure out what is and what is not related to tow. We just had a decision come out of the State Office of Administrative Hearings saying that after-hours fees were related to tow. It's a complex area. The ones that we're really putting our attention is where it's not on the non-consent tow fee schedule. A tow company that performs incident management tows can charge just about anything it wants to, as long as the fee is on the non-consent tow fee schedule. If it's not on the fee schedule, then we'll say that it's not related to the tow. But there's some really interesting questions that are coming up about what are the charges related to a tow. If somebody has a 3% surcharge for fuel, is that related to tow, or is it just a way of increasing profits? These are the cases that we have to go through one by one, where there's a real question. We take it to the commission through a SOA hearing, and let the commission make a decision about what specific facts are, or what specific activities are or are not related to the tow. And then failure to issue tow tickets. Again, we're seeing this too often where the vehicle owner is not given a tow ticket at the scene of the accident. I would say, again, this happens frequently in flip cases because the tow driver doesn't want the vehicle operator to have any evidence. But it's usually intentional behavior. It's not just mere oversight. But given the number of tows that happen every single day, the fact that there's only 18 so far that we've got shows that, again, the great majority of tow truck drivers are doing a good job complying with the law and being safe and confident in the way they work. Let me just see what other interesting information we have. Okay, so now we're moving on to the VSF statistics. The failure to timely send and publish notice has the VSF allegations has skyrocketed because the Department of Motor Vehicle now, when they get applications for titles for salvage or junk vehicles, they do their own look at the first and second notice to ensure that they went out timely. And if they didn't, they refer the case over to us. And so we're getting a lot of these cases of untimely first and second notification letters going out. We do consider these important when there's actual consumer harm, when somebody's actually had to pay extra money because they didn't get the first notification in time, or if they lose a car because they didn't get the second notification. Most of the cases from the Department of Motor Vehicle, there is no real consumer harm, and so we're not imposing penalties, but rather giving warnings because those cars are junk or salvage vehicles, and the consumer never sought to obtain them anyway. Failure to release with proper documents and money. Unfortunately, there's still some confusion out in the VSF world about what documents are required. That might also include, somebody coming in with a title, or somebody coming in with one of the instruments of release that VSFs aren't used to working with. And again, we really want to work with the BSF operators and owners to make sure that they understand what the proper instruments of release are, and the person should be able to get their car back when they come in with the right documents. Now, I'm not going to run through all of these. They're pretty self-explanatory. The bottom one, though, again, that's troubling. You know, the unlicensed companies. These aren't simply businesses that had let their license lapse for a couple of months because of complications, confusion, or inadvertence. These are people who these were businesses that were actually putting themselves out. That's again, these are our primary targets for cease and desist orders in order to better protect the public so that the cars go to licensed, legitimate vehicle storage facilities rather than unlicensed body shops that are trying to pose as vehicle storage facilities. Then down in the next column that begins resulting in disciplinary action, you can see the numbers drop significantly. The number, the allegations, what we actually prosecute drops from the allegations, and that's not just because the allegations are unfunded, but again because we really try to work with our license holders to bring about compliance rather than seeking disciplinary action. The one that I guess most troubles us at this point is towards the bottom, third from the bottom, didn't cooperate with the department's inspector or investigator. You know, we have really hardworking inspectors and investigators who are covering a lot of programs, and it's their responsibility when we get a complaint to go gather the facts and the evidence so that I and other prosecutors can know, has there been a violation of the law? Unfortunately, companies just don't respond to their requests for information. And then that leaves us in a lurch trying to give a fair and reasoned decision whether or not to prosecute a case. We've been prosecuting these more frequently now, only because with the investigators and inspectors having to run so many more programs and us getting more programs, it's essential that they get their data, their facts, and the evidence compiled and shipped over to us promptly so that we don't have to sit on cases or refer them back to them in order to make reasoned decisions about whether to prosecute or not. So I think of all of these, the one that is most troubling to me is the failure to cooperate with an inspector or an investigator, simply because it interferes with our ability to be impartial, rational, and efficient in moving cases across our desks. I think a lot of times the industry thinks that if they turn over records as they're required to by law to our investigators and inspectors, they're shooting themselves in the foot. But as you can see from the numbers we've already gone through, by far the majority of cases are closed, and those that even where there is a violation, we reach out and try to work with the companies rather than prosecute them. So it's really in the industry's best interest to give us the documents, but when they don't, we do prosecute for failure to cooperate. Let me move on then to some of the cases just to give you an overview of what we've been working on this year. The first one is an interesting case because this was a vehicle storage facility, which among other things allowed unlicensed tow trucks to bring vehicles into the vehicle storage facility, unpermitted trucks to enter the storage area and store vehicles in the VSF. Those tow trucks belonged to Ash Towing, which is also one of Mr. Hernandez's businesses. So what Mr. Hernandez did was he was using his expired trucks, knowing that the trucks were expired, to bring vehicles to his VSF, knowing that the trucks were expired and should not have been towing, and then knowing that the VSF should not have allowed them to begin with, we took very seriously. We had an administrative penalty of $68,000 rendered against Mr. Hernandez's tow company, Ash Towing, and then in this instance, we issued a $43,000 penalty against the Ash Towing Recovery as the VSF. None of the penalties have been collected at this point. But in this case, we felt it was important to go after the allowance of unlicensed trucks into the VSF because Mr. Hernandez knew the trucks were unlicensed, and he was using his VSF as a way of allowing his trucks to continue to operate. The next case is a decision that I was talking about earlier that came from a proposal for decision issued by an administrative law judge at the State Office of Administrative Hearings. The administrative law judge, after hearing the evidence, recommended that the commission impose a $4,000 administrative penalty and revoke Eurostar Records towing company license. This is the case that I was talking about earlier, where our laws have a very finite number of reasons that a car can be towed, especially towed from the parking facility serving an apartment complex. The law does not authorize a car to be parked simply because it's what you might call double parked. That is, it's parked in admittedly a sloppy way where it's on the line separating one parking space from another. This car was towed because it was parked on the line, and the administrative law judge found that this was egregious. The towing of this car was egregious because an agreed order prohibiting and sanctioning Eurostar for doing exactly the same thing had been issued not a month earlier. And so they knew precisely what they were doing, and yet they continued to do it despite the fact that they had already paid a penalty for doing it, and they kept doing it. In some instances, recidivist behavior shows a just an utter disdain for the law. In this case, the administrative law judge and then ultimately the commission found that this company was very disdainful of the Towing and Booting Act because it continued to do conduct which it knew and had been sanctioned for doing in the past, and felt that relocation was the appropriate sanction. The next case, Mr. Mraz, DBA FM 1960 record, that's what I referred to earlier as a flipping case. And I quoted pretty extensively from the proposal for decision issued by the administrative law judge. The tow truck operator used deception to obtain the vehicle owner's authorization or purported authorization to take the vehicle to Mr. Mraz's body shop. Mr. Mraz, who's the license holder, who was the license holder for FM 1960 record, also had a body shop, Gamble Collision, not 60 feet from his tow company. And so he was using his tow company to take IM tows after fraudulently tricking people and signing authorizations to have the car go to the body shop, over to his body shop. Again, this caused the administrative law judge to find the conduct to be especially egregious. The license, his tow company license was revoked. An administrative penalty of $4,000 was assessed, but we've not collected any portion of that penalty at this point. I put Toby's Towing and Recovery in here because it just is an instance of where we get reports from our field inspectors, and we go out and do on-site visits of VSFs and ascertain whether or not the VSF is running in compliance with our statute and our rules. These come to me then as inspectors' reports. I look them over, and if they really show bad conduct, we'll go ahead and issue a notice of alleged violation for the way the VSF is being run. The inspectors not only look at the physical premises to make sure all the signs are posted properly, the fences are of the adequate height, the grounds are not overgrown, but also we'll do a spot check of records to make sure, for instance, that first notice letters are going out on time, that copies of the tow tickets remain in place, that there is an effective and efficient drug testing policy, and that the records maintained by the VSF are the records which are required to be maintained by law. And when some violations are found, they're not what are called direct to enforcement, or DTE. We just don't feel that they have sufficient consumer harm to warrant a prosecution. We'll do a warning or we'll ask for follow-up to show compliance. But in these instances, these are direct to enforcement cases because of the nature of the violations do pose potential for consumer harm. And as a result of that, these were prosecuted, and the $2,300 administrative penalty was assessed through an agreed order, and that's been paid fully. I think one of the benefits of an agreed order, not only does it allow people to reconcile and understand and accept that errors have been made, but we generally we're generally able to collect on the administrative penalty. The next case that I put down on here is Megan DeVoy, doing businesses all about the tow and Tomball Towing, Texas Towing Storage. This was ancillary to a flip case, a BSF 11. From the vehicle storage facility and transfer it somewhere else. We had found that she had notarized a BSF 11 without the vehicle owner's knowledge. That is to say, the vehicle owner was tricked into signing some documents. He then left. The BSF 11 was completed, and then she notarized it, and in order to make it look like it was a fully executed, properly notarized BSF 11. So we went and we did get an administrative penalty and suspended the towing company license, probated for 2 years. We have an administrative penalty of about $5,000. But this is an example of some of the probationary terms that we can use to try to get people who violated the law to try to come into compliance and sort of hold them on a tight leash. Because our feeling is that if we can work with the industry and show them that you can still make $1 by operating in compliance with the law, they very well may give up past practices that might have been a little bit outside of the legal limits. The last paragraph, D, these were just body shops and vehicle storage facilities that in our records we knew had a history of flipping. And so they agreed never to take them there. The nice thing about an agreed order is that we can put in just about any terms we want, and as long as the executive director thinks that they're fair and adequate. But we felt that not having cars taken to these facilities, preventing her towing company from having cars taken to these facilities would cut down on instances of flipping, and it has. We put these terms in a lot where we know who the flippers are, those tow companies and DSFs that fraudulently transfer vehicles to body shops in order to assess those bogus and fraudulent fees that I was talking about earlier. Those $3,000 to $4,000 fees that attach immediately when a car gets brought to the body shop. And when a car gets taken to the body shop, I mean, it's horrible because, say, with Mr. Mraz, in that case we looked at earlier, the tow from the BSF to the body shop was all of about 50 feet, but the transfer tow was charged as a consent tow at $250. And so there's a lot of money that's being lost by consumers to this fraudulent behavior. I have to say that flipping is probably one of the most time-consuming but important sets of cases that we have, and it's nice to know that the two other transportation team prosecutors, Mr. Aradia and Mr. Reed, are gaining speed very quickly in these cases. I think that's it for everything I have to present, unless there's any questions that people may have. Happy to answer them.
Madam Chairperson, I do have some questions.
Sure, go ahead.
Okay, so Mr. Sharp, thank you for your report, and I appreciate the detail that you've gone into providing these data and this report to the advisory board. I know that at past meetings, I had asked for more detail, and I feel heard. Absolutely, there's some detail in the enforcement report. Since this is a new format, I just want to make sure that I'm understanding it correctly. And also, I do have some questions. My first question goes back to, I'm looking at the statistics on page 2 of 6. And my question is, I would imagine it might be under case outcomes, but where's the data that reflects cases, whereas the outcome as the case has been closed, because it does not appear that there's sufficient evidence of a violation that has been found. Where's that data reflected?
Well, I think, I'm just looking at this with you as well.
Okay.
We have the performance measures on the top, cases open, 1,051. We have cases closed under tow column, 941. And then if you would, I suppose, subtract these other cases, the 6 commission orders, the 28 default orders, the 31 agreed orders, the relocations. So that's about, what do you want to say? That's, let's just round it up to 1,000. I think you could say that somewhere in the area of, I don't know, 80% of our cases are closed for insufficient.
What was that? I'm sorry.
I want to think about 80%.
So Mary Winston here, TDLR. Tasha, I know we're doing math here, and some of us don't do math well. That's why we did other things. But we can come up with a number for you. And I'm not going to ask Michael to do that today. He's done a fantastic and in-depth report. But you are subtracting some of these numbers will get us there, but we can get that information to you after the meeting and to the whole board. If, we'll just get that from enforcement and make sure we have that set number so we don't have to do the math in the middle of the meeting.
I completely appreciate, and I, if I wasn't understood, I think what my question is, I wasn't asking for the number of cases. I just wanted to see where's the line item on the report.
Okay.
And my recommendation would be to have that line item so that we're not in the middle of a meeting trying to figure that out. We have it provided by the division, if possible.
Oh, yeah.
Yeah, so my question was, where is that? And so if it's not currently reflected, that would be the one area, piece of data I would like to see on the reports. And then the next two, and I'm not going to belabor this, I just want to make sure that I'm understanding this correctly, is I see that under performance measure, there's cases that have been opened and there's cases closed. Can we get a line item that shows how many were already pre-existing, how many were the existing cases that were open? And then of course we have the additional cases that are open and cases that are closed. And these are just some recommendations, and I'll have the why. If I can just, the why is, I feel like the statistics that are here are great. These figures do an incredible job to demonstrate the performance of the department. The department, I can see, is there's a percent of how many cases are resolved within 6 months and such. That's good work, because that's a lot of cases and your caseload is so heavy. It's definitely a positive. Having said that, I feel like the data that I've just recommended will also be able to demonstrate the work of the industry. So there are many cases, complaints that are filed, and as the industry, it would be great to be able to have an indication of how are we doing in comparison to the volume of cases that are received. We have a lot of data on cases that are closed and disciplinary action, but I think that it's important as a regulatory board to be able to show and see how are we doing. We see the negative, but I think we also need to see that figure of the cases that are open, how many are closed, because it does not appear that there's sufficient evidence of a violation. And I think that the industry deserves that, especially with so many trying to push the industry in a positive direction. It'll reflect that the commitment to compliancy as well.
So Mary Winston, TDLR, I think that's a great idea. It's kind of looking at the same thing, maybe turning it around and looking at it a little differently. And as you can see, this report has been expanded as, was requested. And so it's a fluid process. And our analysts Chris Russi and Griselda Perez. They are typically listening. I'm sure they are. And even if they aren't, it's recorded, as we know. So you made a request, and we will do another little tweak and try to get that on there. So, Michael, you may have an extra line to go over, or two to go over next time, and I'm sure you don't mind.
No, of course not.
Awesome.
Just a couple of things I noticed very quickly. The cases that were closed as insufficient evidence are included in the informally resolved. Informally resolved includes insufficient complaint resolved and other informal resolutions. So the insufficient is a subset of that larger informally resolved. Then and also with respect to open and close, we do have cases open and cases closed as the first item in our performance measure, to show our work product and how we're generating. So maybe that responds to Ms. Moore's second question. And while it's not a perfect indicator, the informal resolved includes insufficient evidence, the complaint resolved, or other informal resolutions.
So that's perfect, y'all. Mary Winston again. And I just had, thank you, Chris. He just messaged me and let me know I'm listening, and he's heard your request. Thanks.
Okay, any other questions, board members, from Michael Shirk? Really? Okay. Michael, thank you so much for that detailed report. I hope one day that we get that report down to where there is very, very little, but I don't know that we're going to get there. Okay, thank you for your time, and also congratulations to your entire team. It's amazing all the promotions and changes that happen when we don't see you guys for a year. Y'all are just moving right along over there.
It's a good group.
Thank you. Okay, that takes us to education and examination. John Schildwater, I think you're new.
Good morning, board members. Good morning, presiding officer. My name is John Schildwachter, and I'm with the Education Examination Division. And today I'll be sharing the statistics with you from our division. First off, you see the continuing education statistics as of July 31st of this year. Those numbers are fairly self-explanatory. Moving down to the next section on curriculum. Those are the curriculum approvals so far for this year as of July 31st as well. Moving down, this is for the fees for CE. As you all know already, the fees have been waived for June, July, and August. And what you see there are the numbers for, again, through July of this year. That pretty much details the entirety of my report. I'm available if you have any questions.
Any board members with questions on that report? I do have one, John. So they've waived fees through July, it looks like. Is there talk or discussion about waiving it for the next few months, next quarter? I mean, obviously, we don't really know where we're headed. As Mary said, we're taking it slow and safe, but just curious, September, October, if we have any idea on that yet.
I'm aware that they've been waived through August. Beyond that, I do not have that information. I'm sorry. I can get that to you, or perhaps one of my fellow members of the E&E can chime in, but I'm sorry, I don't have the information right now.
No problem. I didn't mean to put you on the spot there. I was just curious what we're looking at for the future. I mean, the industry is definitely suffering from all this, so just curious.
Thank you.
Any other questions, board members? Okay, they're awfully quiet today. All right, thank you, John.
Thank you.
All right, that takes us to Customer Service Division, and I believe Miss Mary Winston's going to report on that.
Yes, thank you, Chairwoman. I am pinch hitting for customer service today because they are in the middle of trainings to do with this platform and other platforms. And we had their report. And as we're working in the background, I'm like, sure, it's plain and simple. Let me just kind of run through the report for the board. As you can see, we have the fiscal year basically from September of last year until the end of August of this year. And it's pretty self-explanatory because the calls are in blue, emails are in orange, or it looks sort of gold on my computer. Not sure what it shows up on your screen as. But what we're seeing is somewhat consistency. We had a dip, and through the summer, we've had pretty consistent numbers around 2,000 as far as contacts, customer service contacts. Of note is the amount of phone calls that have increased, but if you really look at the actual full year, it looks pretty consistent. But it seems like this summer we've gotten more phone calls than we have emails. They've been a little lower, and who knows? That could be because people have more time to talk. Because when they're busy, they shoot an email and wait for a response. And since all of us have been sort of sidelined a bit, or our wings have been clipped just a bit, we've reached out in phone calls. And so that's what customer service is seeing right now. If you have any questions, we'll put them on the record and we will make sure we contact customer service and get some responses for you as soon as we can.
Any questions on that report, board members?
Ken Ulmer. Mary, I was just curious, how does it normally run with emails versus calls? Have the email contacts gone down?
Email contacts, Mr. Ulmer, have gone down for the last few months. At the same time or at the beginning of the fiscal year of last year, emails were a little up, but actually so are our phone calls. So it looks like people are calling in a little bit more versus emailing, but it looks pretty good. It looks pretty steady. There's not like a huge jump. And considering all that's going on and different things that we've had to announce and different information, that actually looks pretty good.
I was just curious because I know in our business, emails and things of that nature or electronic type formats have actually increased. So I was just curious as to why they had dropped off so much.
And typically, Mr. Ulmer, depending on the program, we will have, well, it just depends. Some programs we have where people prefer to call in. Some programs we have that people prefer to do email. And the emails have actually decreased. For instance, last year about this time, we had 385 emails compared to 1,700 plus calls. This year around this time, we have 118 emails versus about 1,900 phone calls. So little bit of switch there. Emails are down a bit, but it's a fluctuation and it's not abnormal. The contacts seem to be consistent, just the way that they're contacting us. A couple of hundred people decided I'm going to do a phone call versus an email.
Great, thank you.
Okay, any other questions for Ms. Winston? All right, thank you, Ms. Mary. I think we'll move on to licensing division. That would be Laura Hernandez.
Good morning, board members. My name is Laura Hernandez. I'm a licensing manager in the licensing division for the tools program that handles the towing and vehicle storage facility program. Before you, you'll see our report as far as the statistics go. You will see the ones for fiscal year 2019 and for fiscal year 2020. The numbers remain the same, not a huge drop either way, either going up or going down. We're still seeing a high percentage of everybody doing online renewals, online applications. And you can see the breakdown. If you have any questions, please let me know.
Any questions, board members?
I did have just a couple of questions. So that I completely understand, population is the total number?
Right, that's the total population for that program at the time that the report's looked at.
Okay, so new and renewed added together would not be population?
Yes, yes, those are the total licensed population.
Okay. They don't quite work out to the exact number.
Well, what we found is that when we run these reports, because of the online system that we use, if there's a company that is licensed, however, maybe their insurance lapsed or there's something pending when they renew or when they apply, they don't get added into that total number. So while they still may be licensed, they aren't included. So that's why you'll see that differential in there. It's just hard for us to get that program to include everything the way that the system is set up. So yeah,
Okay,
there
thank you.
there is some missing. It doesn't mean that they're not licensed. It just means for whatever reason that the day that report was run, they were just missing something, or the system hadn't updated. Maybe they renewed and the system hadn't updated yet, and they weren't included in those numbers.
Great, awesome, thank you.
You're welcome.
Anyone else with questions for Laura? All right. Thank you, Laura, for your report.
Thank you.
Ms. Milstead, you're muted.
I'm so sorry. Thank you, Laura, for your report. I apologize. That brings us back to you, Miss Mary, for Executive Officer report.
Thank you so much. Before I begin the executive officer report, I do want to say, and before I announce it, yes, we did get a message in the background from Mr. Kyle Jackson, just letting us know that he had to exit the meeting a little early. So I just wanted to get that on the record that board member Kyle Jackson exited the meeting at 11:30. Okay, now for the executive report. Again, good morning. My name is Mary Winston, and I'm the advisory board attorney, and I'll be bringing the executive report today. I want to begin this morning by talking about TDLR's COVID-19 response. What I'm going to talk about today is going to refer to our website page. The title of that page is TDLR Takes Action in Response to COVID-19 Threat. Our response has been both internal and external. Externally, we've acted and continue to act as sort of an information conduit, relaying information as it becomes available from the Department of State Health Services, Centers for Disease Control, and the Office of the Governor. On this webpage, you will find that we have links to all of Governor Abbott's executive orders. And for those who signed up to receive emails from TDLR, you began receiving emails related to your program of interest and the COVID-19 requirements around May 1st. Internally, well, I previously used the analogy of ducks gliding smoothly on the water while their feet swiftly paddle under the water when I compare the works and actions of TDLR staff internally to best and as smoothly as possible serve our licensees and the rest of the citizens of Texas. In March, our IT staff, led by our executive team, moved with almost unimaginable speed to relocate as many in-office work staff as possible to remote working status. We still have mailroom staff that had to remain, got to get that mail out, and we still have finance staff that had to remain, got to process those funds. And some of our systems we can't make remote because of the sensitive nature of the program. Money is one of them. We maximized all existing remote platforms and we learned and incorporated new remote platforms. Thank you, Mr. Fickle, that allow us to communicate within the agency and for external meetings such as these. This has not been without internal and very personal disruption. We've seen staff members who've become ill or who've had family members to become ill. We've had to temporarily close our offices to have them deep cleaned. But TDLR staff has truly shown a tremendous spirit to serve the public in spite of all the setbacks. The core values of the agency have definitely continued to shine through, and I'm happy to say that I'm a part of that. B, TDLR strategic plan. This also can be found on TDLR's website. We provided this required plan to the governor's office on June 1st of this year. It's entitled Leading Texas to a Brighter, Stronger Future. This planning document is a roadmap that provides direction for our staff and the public on who we are, what we do, and how we do it. Of note, the plan introduces our new anti-trafficking unit and our drive towards anti-trafficking. It discusses the Sunset Commission process and includes information on how TDLR plans to deal with disaster preparedness and the planning for it. It also incorporates the input of the commission members, advisory board members, staff, and the public. This is the time where, if anyone's familiar with TDLR, you would generally see teams of us going around the state to set up. We rent these conference rooms, we invite the public, we try to get it out there on social media, and we ask you to come in and tell us what we do well, what can we do better. If you were king or queen for a day, what is the law, rule, or policy of TDLR that you would change? We couldn't do that this year. So we crafted questionnaires, we conducted surveys, and we held virtual strategic planning meetings to gather public input. We really worked hard on this plan, and we don't do it just once every year, every other year. It's something that we really do try to work hard at to make it thoughtful, innovative, and functional for our licensees and for the citizens of Texas. Again, this is available for your viewing pleasure on our website, and please take a minute to take a look at this when you get a chance, if you haven't already. This brings me to see the Sunset Commission report update. The Sunset staff began their review of our agency on last year. Led by project manager Emily Johnson, the Sunset staff took a really deep dive into all of TDLR and its processes. The Sunset process is not meant to be complimentary. It's not designed to objectively and critically assess the functionality of the agency. That means the good and the not so good. And it notes places where we can do better, and the staff offers solutions for that. The Sunset staff worked extensively on their report. They observed the agency over several months, interviewed staff, commission members, advisory board members, and collected comments from the public that are still available on the Sunset Commission website. They then drafted their staff report. It was a long process, but it was one that we welcomed because we know that TDLR will become a better agency from this deep dive. And if you want to make some more comments on this report, please go to the Sunset Commission website. They're still taking public comment. Next step for all agencies who underwent the Sunset review: hearings concerning the staff report. These will be scheduled at a later date, and we'll keep you posted. Good news: the Sunset staff recommended that TDLR continue for another 12 years. Lastly, our communication outreach statistics. This is a snapshot of online activity for tow truck drivers and operators and VSF facilities, and what they've done when they've come to our website, what they've looked for over the past 6 months. What we've seen is typically from March to September, and then we try to kind of encapsulate different parts of time or sections of time. The website has had over 165,000 views, a average of almost 900 a day. 35% of those visitors access the site from their desktop computer, and 63% did so from a smartphone, 2% from a tablet. Now, that may seem like an odd thing to gather, but it's really not, because it lets us know where our folks are and how they're looking at us. And we haven't developed certain technology yet for different apps and things that some folks have recommended. This kind of lets us know how prevalent this need or requirement would be for your program. The top reasons for visiting the site: number one, consumer information about towing. Number two, how to apply for a tow operator license. Three, questions on laws and rules. Four, you're looking for forms. And five, how to apply for a tow truck permit. Now, these are the statistics that we've come across and the frequency of contact that we have. And actually, this wraps up my report. If anyone has any questions, before I stop that, we do have our Deputy Executive Director, David Gonzalez, here. And if he would like to add something to this report, I would appreciate it. And then we'll take questions after that. David?
Ms. Winston, phenomenal job as usual. Chair Milstead, advisory board members, just want to compliment my staff on the record in front of you guys. The efforts that they went through to prepare us for a pandemic response that we had no clue that was going to happen. We were prepared for all kinds of other disasters, but the IT section working together, all of our staff working from home and being as productive as they can be, especially those staff that still had to be on the front lines to come into the office and still do things, has been phenomenal. A few points, Mary. I want to reiterate something that Chair Milstead said earlier on. We're doing business in a different way because of the pandemic, and we're all being made accustomed to new virtual meetings and how we're doing our business, virtual inspections. It is going to make, no doubt in my mind, this is going to make us a better agency because we're having to be more creative and come up with different ways to serve the public, which we already took pride in and we're doing our best on. This has shown us that there are alternative ways to get our job done, but also alternative ways that our public is expecting our job to be done. So just the point that you brought up about us having to work through this, no doubt in my mind, and it's included very prominently in our strat plan. We actually had a question and a goal related to planning for the next pandemic, planning for the next disaster, and it's incorporated into our strat plan. Also, of course, the most important thing for us is being continued for 12 years, but this is not a love you report. They're actually taking issues with things that we do or accomplish or don't accomplish enough of. There was actually 7 issues that they address, and I would encourage you to read through those issues. The only ones that touch so much on the Toad Advisory Board is a specific recommendation related to advisory boards and how they may communicate. There may be some cross coordination between advisory boards that could touch on y'all's particular program. And also there was a recommendation to have vehicle storage facilities moved to a different agency, which could have some effect on at least who you're communicating with and how we interact with that other program for vehicle storage. But those are the only points that I wanted to bring up. Like I said, you did a great job, Marianne. I appreciate the time available for any
Thank
questions.
you. Before we move on, I do want to get some information for Ms. Mora. Thank you, wonderful enforcement staff, and I knew they were watching back there. And for fiscal year 2020, and we will definitely take this as part of future reports, but Chris Rusty came up with this information, like on the spot. Cases closed for insufficient evidence are as follows. For tow, it's 449, and VSF, it's 176. These numbers are included in the sum of cases informally resolved, as Mr. Shirk has told us earlier. And thank you, Tasha, for bringing that about. And thanks, Chris, for that information. And sorry for interrupting again. If there are any questions for me or Deputy Executive Director Gonzalez, please let them roll.
No questions again from the board? Ms. Mary, thank you for your report as always. David, thanks for joining us. We appreciate your input. Although I don't think I want to prepare or train to have our next pandemic. I'm not looking forward to something like that ever. Okay, so that concludes all of our staff reports. Would the board like to take a brief recess, or do we want to keep rolling here?
I say let's keep rolling.
Okay, nobody else? All right, then now takes us to item H on our agenda, discussion and possible appointment of an education work group to examine our CE requirements. Miss Elizabeth, did you want to start with this, or you want the board to take over?
Sorry, trying to unmute myself. You go ahead and start the discussion, and if I need to refer to any applicable rules regarding the CE requirements, I am more than happy to do that.
Okay, I'll just give a refresher on this. We brought it up at our last board meeting, which was like a year ago, if any of you remember. We wanted to revisit the CE requirements simply because our industry is still suffering for so many fatalities in the line of duty. We want to review the requirements that have been put in place and over the years that have been tweaked a little bit, but we want to make sure that our safety is addressed and that we're giving adequate training on that. And I know with Ken Ulmer on the board, he can probably bring some value to that piece. But basically, that's what this conversation was about. And then I guess we'll open it up if any board members want to address it. I know Elizabeth has some input as well.
I think this would be the appropriate time to tell you the applicable rule, just so you know the confines in which you're talking. So our applicable rule for CE is 86.250. And 86.250 currently requires a total of 4 hours of CE through department-approved courses. And the CE must include 1 hour in roadway safety, 1 hour in Texas law and rules that regulate the conduct of towing operators, and 2 hours in any topic that's listed elsewhere in another subsection. So right now, you have 4 hours. You could seek to add, I spoke to our E&E folks, you could seek to add some additional hours. That would require a rule change. Or you could seek to possibly change up the topics, but that would also require a rule change. So just keep in mind that if you want to add something, which would either be hours or an additional topic, we will have to go through the rulemaking process. If you could find a way, and I'm not suggesting this, but I'm simply putting it out there, if you could find a way to add in whatever content you want to add within the existing structure of the rule, let's see if that's possible, and we might be able to avoid a rule change. But simply adding additional hours or adding a new subject most likely will require a rule change, which is fine, and we can go through that process. I just wanted to make sure that you all understood that as you enter into your discussion.
So Ken Ulmer here. I think one of my big concerns with the CE requirement has been that some of the content for CEs is very lackluster, very off topic. It's basically geared to get a dollar fee out of the applicant. And in my opinion, very lightly meets the requirements and certainly doesn't meet any actual real day requirements. And I think other, CE providers do an amazing job. So I would want that discussion to lean more to, are we really providing, is every CE provider really giving information that is worthwhile? And the other part of it is, what do we do about, and I may be stepping out of bounds here on the limitation that we can talk about, but what about providers who are not providing anything and they're simply taking a fee and allowing someone to get their hours and posting them on the website? I mean, we know that that is happening. What's your input on that?
I would need to defer to E&E on what their process is if they were to receive a complaint, because remember, our CEs are department approved. So if there is an issue with a particular provider or a particular CE not providing the actual substance that is promised, that's something that our staff needs to be aware of so that they can look into that. With regards to the kind of instruction that you're asking about, whether it's really helpful to the industry or whether it's just something where somebody pays a fee and gets a stamp and moves on, right, for their licensing renewal, it might be helpful if you wanted to consider a work group to explore. So that's always something that's available if the board decides, okay, well, there might be some additional issues here, not just possibly adding in some additional topics. Maybe we also want to talk about things like, are our licensees actually getting what they need? And is this something that the department needs to be looking into? That's probably better accomplished in a work group setting. You certainly are free to discuss it here. I'm just putting out what your options are. So again, our not knowing, not being part of E&E and not knowing whether they've received any complaints at all about the topics that are covered in the CE, I can't directly answer your question. What I can say is if there is a concern about a department-approved course or provider, we need to know about that.
Okay.
I agree. Quality is always a concern
But I would like us to take a further look at the preponderance of more electrical vehicles that are out there. And is there any safety that we can have around that? With mechanical breakdown or electrical breakdown of electrical vehicles, and also resulting from a collision with exposed batteries. I really want to make sure that we keep the tech safe on the road.
Yeah, this is Charlie Rash. I think that we could break the 4-hour classes into 2 groups too, because I know when I watch CE, most of my trucks are light duty, and they get off on heavy duty, and you really just lose interest in the whole thing. I would like to be a part of a work group to check into different ways of doing it.
I wouldn't mind being Ken Ulmer. I wouldn't mind being a part of that work group either. And one of the things that, and I know this costs money and it takes time to get these types of things done, but possibly we could get some feedback from the industry when they renew their license, because that's going to be close to the time they take their CEs. We know we as an industry sometimes procrastinate and take our CE like very close to the time that we renew our license. So possibly we could get some feedback from those people as they renew their license. You know, it could be voluntary in that, you know, did I really get something out of this CE? What could they have provided to me better? What, just some kind of feedback that we could then publish and make known to CE providers. I think that that could be helpful. There again, I know that's costly and I know it takes a lot to get that done, but then we would be getting feedback from the actual people who were reviewing these. Obviously, myself included, I can't take every CE, just don't have time to do that. But I know of the ones that I have taken, I've, you know, in my mind said, wow, this one's really good and this one's really bad.
Gary Hoffman here. I want to reiterate kind of what Charles was saying, especially with the heavy duty guys. They have very little interest in this, but I would like to encourage some more hands-on, I think, and I know it's hard to do, especially in the time we're in right now, but I think the hands-on training is a lot more beneficial, and especially with the safety aspects. Some of these big heavy-duty courses that are put on count for our CE training, and I think that's great. And I know the timing is due, but even on a light duty level, I think those guys need that, especially with all the safety concerns that we're having right now. If there's some ideas or some kind of something that we can do requiring it at least every years a course in the same continuing education all the time, that some of it's, but a lot of it's not, like what Ken and Charles both have said there.
So Mary Winston TLR, Mr. Hoffman, you broke up just a little bit, but I think we got the gist of what you were saying, and we may have some more comments that come in. You're coming in loud and clear now. I don't know why well, Wi-Fi, who understands it? But we hear you now. There may be some more comments, and the hard part of this is for the presiding officer because she's got to pick that work group. So I'll let you continue. Oh, and you flashed off again, but we're still moving forward.
Tasha Mora, I would also like to be part of that work group. I also, there's just concerns, and I think this is good dialogue that we're already having. I think being part of the work group would just open that up. And there's absolutely a concern with driver safety, especially with the volume of tow operators that are hit on the side of the roadways, killed, lose their lives and such. And so I absolutely like to be considered to be part of that work group.
Okay, sounds like we've got some great discussion and a lot of concerns from the industry here on the board. Elizabeth, so we have 3 board members that want to be a part of that. Can we have a 4th, or is that not an option?
Anna is nodding yes. I was looking in her little square. Yes, we could do a 4th on the work group. Do you have a motion that you'd like to put forward?
Can I get someone to, do I need to make the motion, or someone on the board needs to make the motion to put a work group together to review the CE hours.
Oh, let someone else make the motion. And honestly, this is one of the things that, you decide. So for who you pick, presiding officer, that is at your discretion.
Okay, can someone make a motion to?
Ken Ulmer, I make the motion to have a work group related to CE requirements.
Charlie Rash, I second it.
All right, we have a motion and a second. Anna, is that all you need to put that in the minutes?
I'm going to take a vote.
Okay, go ahead.
Thomas Griffin,
Aye.
Jimmy Zoki,
Aye.
Kyle Jackson is absent. James Spears,
Aye.
Tasha Moore,
Aye.
Gary Hoffman. Oh, I think Mr. Hoffman froze. Gary Hoffman,
Aye.
Charles Rash,
Aye.
and Ken.
Aye.
And presiding officer Amy Milstead.
Aye.
The motion has passed.
Okay, so with that being said, I'd like to appoint Ken Ulmer, Charlie Rash, Tasha Mora, and James Spears. Would you be willing to do that as well?
Oh, yes, I would. Thank you.
All right, perfect. So Anna, we have the names there. I have two questions for you, Elizabeth, while we're here.
Yes.
Of the 4 hours that you discussed, 1 hour is safety, 1 hour is rules, and 2 hours for any topic. Would we have the availability to switch that up, like 2 hours of safety or something else, or does that have to go back to rules?
I think if you make changes that alter the way the current rule reads, you will have to do a rule amendment. So,
Okay, so the rule
changing
does read
topics, adding in topics, adding in hours, that's all going to be through a rule change. I say that with the caveat of once your work group gets into the discussion of what exactly they would like to add or swap out, I think we can revisit that question so I can take a look at what you're wanting to add in relation to how the rule currently reads to see if I can fit those topics into the currently existing topics in the rule, because they're actually very broad. So we can take a look at that and have a further discussion.
Okay, great. That answers that. And did I understand you correctly with if we review the current CEs that are approved, if it comes to the conclusion that there are some that are just not meeting the qualifications that the industry needs or wants, how can we do something with those? Are we stuck with those, or can those be revisited? Does the staff have the opportunity to decline those or reject those? Where do we go from there?
We would need to bring E&E into the discussion and talk with them about what their process is. Obviously, with so many programs that we regulate, it probably is not uncommon to have a provider here or there in any program that is not meeting the expectations. And so I don't know what their process is for addressing that. And so we need to bring E&E to the table to ask them what that process is. Oh, Mary.
Oh, and I wanted to add that with the work group, it's a work group for the advisory board members, but there's also going to be a staff person there. And because this is dealing with CE requirements, E&E, someone from our education examination division will be a part of that conversation. So they'll be able to guide depending on the recommendations of the work group. If there's a recommendation and, oh, that's statutory, we can't do it. That's something that staff will let you know, or they'll contact Elizabeth and say, oh, the rule's broad enough. I think this can, not change substantively the rule. That's something that staff will help provide guidance, and the work group from the advisory board will provide that expertise for those recommendations. And we'll kind of let you know what we can do and what may need to, we're coming towards another legislative session next year, which is very soon. So if that's something that needs to be put off until then, so we can kind of get those recommendations and see how best we can do them actually.
Perfect. Thank you, ladies. I feel really good with this work group. I think we've got some really good folks involved in the safety aspect and really want to take care of our industry on there. Do we have any more discussion on this? Okay, I guess that takes us on to our next item, discussion of possible rule relating to
Chair
the,
Milstead,
I'm sorry, go ahead.
I would like to interject my crack staff. This is David Gonzalez, Deputy Executive Director. Our crack staff and RPM, Mr. Todd Forrester, pointed out that I may have misspoke during my sunset report. I have VSF and APR and everything on the brain. It is not VSF that is being proposed to be moved to Texas DMV. It is APR. So I just want to make sure. I probably sent a shockwave of concern to all the VSF facilities out there. It is APR that is a recommendation that it be moved to DMV. So if you're paying attention out there, the listeners, just want to make sure to make that clarification. Thank you, Todd, and thank you, Chair, for letting me interject that. Don't want to cause undue panic.
Thank you for clarifying that, David. I know that will put some minds at ease out there. Okay. If nothing else, then we'll move on to item I, discussion of possible rule relating to the towing of vehicles involved in incident management tows to unregulated body shops, generally referred to as the flipping in the industry. I believe Elizabeth Salinas Stripmatter is going to take this one.
Yes, so as the current board members are aware, and I think as even the new board members being in the industry, flipping has become a topic in the state of Texas. And Michael Shirk did a beautiful explanation of it during his presentation on what flipping is and how the enforcement department is attempting to address it. Flipping has become an increasing problem around the state. And so last summer during our meeting, it was suggested that we look into the possibility of whether we could create or amend existing rules to specifically address the issue of flipping. And I believe the concern was specifically with regards to tow operators being able to recommend places for towed vehicles that have been involved in incident management tows to go to unregulated body shops. So we started those discussions, and in the midst of those discussions, the sunset report, which Mr. Gonzalez made reference to, was issued in May or June, I can't remember which. And on page 80 and 84 of the sunset report, there is a little bit of a discussion about flipping becoming an increasing issue in the state. And there is a suggestion that the department perhaps explore a rule specifically relating to the issue of flipping. So we have the suggestion from the board that came last summer, followed up almost a year later with the Sunset Commission saying, yes, that is something that the department needs to look at. So what we are doing now is we are vetting the possibility of rules relating to the concept of flipping through the upper levels of management. And that is currently where we're at. And so we will continue to have discussions within the department that will hopefully be wrapped up very quickly. And then we will know whether we can or can't proceed with rules related to flipping. And if we are given the go-ahead, then we will go into the rulemaking drafting and the rulemaking process, which I talked about during my training.
Okay, does anybody else want to add anything to that, to the topic? I know y'all are awake. I can see you. I'm just not getting many comments out there. Okay, Elizabeth, thank you. I think that we did agree that is a huge topic. I know Ken and Charlie and I, our areas, we see it, we feel it every day, but I know the industry needs to have some direction on that, and we need to take charge on that. All right, I think that takes us to item J, if there's no more discussion there. Recommendations for agenda items for the next board meeting. I'd like to start with the public comment that we got was about out-of-state tow companies and approval of them coming into Texas when there are catastrophes going on. That's something I think Ken and I related to earlier. If we could, Anna, get that on the agenda for the next meeting, and then I'll open it up. Board members, if you have other things or we need to discuss that.
Ken Ulmer, Amy, I'm not sure how clear we need to be, but I want to make sure that it includes the ability to discuss the memo put out August 7th by TDLR in preparing for hurricane season clarification on UCR, tow trucks, and VSFs. So I just want the wording to be inclusive enough that we can discuss that as well.
Can we get that ahead of time for the board prior to that meeting, or is that allowed
Definitely, I can send that to y'all.
for review? That'd be great. Okay, anybody else with comments on that topic? How about additional topics for our next board meeting? It's been a year since we met. I know you guys have some things out there.
Should we have the working group that we're on with CE training have a report out?
Good catch, Mr. Spears. Yes, of course, we need that.
Training as well, where they're not just paying for a license, but they have to have some sort of training because they're at the same safety risk on the highway as we are.
Okay, we have that in the minutes, Ms. Anna?
Yes, ma'am.
Okay. Anybody else? Okay. If we have no other suggestions.
Ms. Milstead, if I can just put out there, would you like to consider the possibility of hearing an update on where we are on the rule?
Oh, absolutely. I thought that was already included. Absolutely. I thought that was already included. I'm sorry. Yes, please. All right. So let's have some discussion about date and time. And I guess the location doesn't need to be discussed because we're going to be virtual, correct? So the location's your office or wherever you're at. Date and time, I do think that this needs to happen within the next 6 to 8 weeks because we're approaching the end of the year and we don't want to go as long as we did last time. It's September and who knows what's going to happen between now and next September. So 6 to 8 weeks out, do we have any ideas or suggestions for that?
Would you like me to poll the board for a date in early December or late November?
Let's see, October. Well, 6 weeks is right at Thanksgiving, mid-November. So are we thinking after December? I mean, what's the timeline look like, Anna, for the advisory boards? When can you fit us in?
November looks pretty clear. Let's see.
I'm looking at maybe November 16th through the 20th. Oh, that's Thanksgiving, isn't it? The 19th?
The following week is Thanksgiving, the 23rd.
Oh, okay. So what does the 16th through the 20th look like? A Tuesday or Wednesday? Anybody?
Wednesday is wide open for us. We have a possible commission meeting on Tuesday and Friday. But Monday, Wednesday, and Thursday are open for you.
Okay, board members, any comment on that? Any objections?
This is Jimmy Zilke. The 18th is great for me.
Okay.
18th works for me as well, Ken Ulmer.
Sasha Mora, the 18th works for me.
Gary Hoffman, I think the 18th will be good with me too.
Oh,
I'm open. I can make the 18th also.
Okay.
It works for James Spears too.
Yeah, Charlie Rash 18th is good.
Oh my goodness, do we have a complete consensus on a date before we leave? This is excellent. I'm assuming 10 o'clock again, Anna, will work?
Yes, ma'am.
Okay, so our next board meeting will be November 18th, your office, 10 a.m. Anybody have any comments or questions, suggestions on that? All right. If that is all the business that we have to attend today, I will adjourn this meeting 12:30 p.m.
Thank you.
Thank you for attending, everyone.
Thanks, everyone. Great meeting, Amy.